All right, we're going to go ahead and get started, everyone. Thanks, everyone, for coming out. For any of you who were with us last month, we tackled pretrial practices, and Gabe was very frank about how he couldn't get his energy up for it. But today, I think we're covering a topic he can get his energy up. Today, we're talking about direct and cross-examination.
Just as we get started, wanted to let you know, any of you who missed part of this, or if you have colleagues back at the office who want to see it but aren't able to make it, we're going to be posting the videos of these on a website. It's saltlaketrialattorney.com. There's a little section on it that says Litigation 101, and it's got, they're going to have the videos. The last one's up there. They're pretty long, so they're kind of low resolution, but you should be able to get the drift.
So when Gabe says something asinine today, next month I confront him on it, and just like I never said that, we can go back to the video.
And of course, it will be edited out, so then I will be proven right. But that's the beauty of having the editing tool yourself.
All right, so today we're talking about direct and cross-examination. And for me personally, cross-examination is the most fun of any trial. You can make arguments for closings, you can make argument for, I don't know, anything you want. But for me, cross-examinations are where if your blood doesn't get flowing for cross-examinations, you should go to a doctor and get checked out, because that's the funnest part of being a lawyer. And to me, cross-examination and direct examination to an extent is really the culmination of everything we've talked about to this point. It's what you've done your discovery for. It's what you've had your experts come in and help prepare you for. It's what you've done your trial analysis for, how you've come up with your theme, your word selection. I mean, it all boils down to this is where it all culminates. This is where you make it or break it for your case. So we're going to start with direct examination, and I like to start with direct examination because, frankly, I think it's much, much more difficult than cross-examination. Anybody get a sense of why it's more difficult? By show of hands, how many people who have done jury trials where they've had to do direct and cross-examinations? Am I talking to a room that, okay, so we've got a few. For those of you who have done it, do you agree with me that direct examination is harder than cross-examination to prepare for as an attorney?
Should be more careful.
Okay, well, you have to be more careful. And can you give me an idea why? Why do you think that is?
Because you can't lead the witness. You gotta be so careful and not get an objection. So you have to really strategize how you're going to ask questions, because you want the information, but you can't make invited objections.
That's exactly right. And honestly, to me, it boils down to control. You can phrase you can prepare and execute your cross-examination to the point that you have pretty exclusive control. There might be times where a witness is weaselly and they try to get out from underneath you, but for the most part, if you prepare properly and if you do your cross-examination correctly, you should have almost total control of that witness. Direct examination, it's a completely different game. I think of a couple of years ago, Gabe and I were teaching a seminar, and I gave this long discussion about how prepare your witnesses, and then be prepared for them to go completely off script and screw your case. It's just going to happen.
Yeah.
And right after
your clients never went to law school.
And right after I said this, Gabe got up to start his presentation, and he went off on some story that was just terrifying. And
did I frighten
remember
you?
this? The Better Call Saul. He called
yeah.
He alluded to Better Call Saul, and there was some really inappropriate stuff in it.
Great
And I didn't know it
episode.
was coming.
It's fantastic.
And I said, "This is your prime example. If I prepared Gabe, I prepared
I
him."
was
and
right
yet,
on
once
point.
he takes the wheel,
That went right to the heart of what we were talking about. It's perfect.
So, direct examination is much more difficult because you have to let go of some of the control. And so what we're going to talk about today are three areas where I think we can do better work and we can do better preparation to help at least eliminate some of that risk. All right, and the three categories that I mostly want to talk about are preparing your witness, preparing yourself, and then we'll talk about tips of execution. All right, so let's talk first about preparing your witnesses. And I love this topic because, to be frank, we have this discussion every single year about the ethics of preparing your witness.
Oh, yeah.
And what is ethical, what's not ethical, what's gray area. And to be honest with you, I think that it's a very, very open subject, and so I invite any kind of feedback you guys have. Let's talk about preparing your witnesses. You should never go into a trial, if you can help it, without having met with each one of the witnesses within your control. And that includes fact witnesses that are just neutral parties, all right? I was amazed one time in meeting with one of my experts in preparation for trial, and we went over her testimony. We went back and forth. I cross-examined her. I gave, we made sure she had everything ready she had to go. And when we were done, when we were walking out, she said, "Thanks, I've done lots of these, and I've never had an attorney come talk with me before trial. Never prepare me before trial." And that astounded me that would happen.
And that's actually rare for what you call your professional witnesses, your cops, your DEA agents, your really, professional expert witnesses, doctors and whatnot, because a lot of them will actually go to seminars where they talk about, they give us instruction in how to testify effectively, how to deal with cross-examination. But I still think it's important that you meet with all of your witnesses, especially, including your experts. Although I think that the part that gives most people the greatest deal of trepidation going into it is, when your own client gets on the stand. Because no one can sink a case faster than your own client, right? Now my philosophy is I try, there's kind of a happy medium in terms of preparing the client. On the one hand, you don't ever want to just have them walk in there and just get up and tell their story, because one of the reasons your client has hired you is to help them present their side of the case in a persuasive manner, in the most convincing and effective way they can present it. Now, on the other hand, you also don't want to go over the story too much with your client, because the client will tend to start repeating your words and just saying it like a machine. And I'm not really concerned as much with, in my practice, with, witnesses who are like, "Well, just tell me what you want me to say." Because if I'm getting ready to try a case, I've already been through depositions with my clients, and I think we've talked about this before. For me, all of these clients represent a huge investment of time, of money, of all sorts of resources, and I am not going to expend that kind of money on somebody who is making the story up or who needs me to tell them what to say. So the ethical considerations, I understand it's important, but on the other hand, I have never gotten to the point where we're going to trial where I have to really worry about it, because at that point, the client's testimony is a little bit set in stone. If you've got competent opposing counsel, they've obviously deposed your client, so it's all there in writing. The client is aware. I think where people get in trouble is walking the line between explaining to your client what the law is and what you need to prove in order to make your case, and on the other hand, sitting the client down and saying, "All right, well, no matter what, you have to say X, Y, and Z, otherwise, you're going to lose and go home with no money." Now, I still think it's appropriate to explain to your client what it is that you're trying to prove, and also explain to them that if they lie, they're going to get caught, and they're going to get in trouble, and you're not going to make any money. So, I think the ethical considerations can be overcome by practical considerations. I mean, if you're walking into trial with a liar, at least on the plaintiff's side, you've made mistakes way down the line that can't really be fixed at that point, other than by dropping the case or dropping the client. Now, on the other hand, I think it is important that my clients understand which parts of their testimony are the most important, which parts are going to be the most persuasive to the jury. If there are 2 or 3 different ways that something could be worded, I can explain to the client which way is gonna be the most persuasive, and, and then make sure they understand that they've gotta tell the truth. And then, we go over their testimony a few times, and then we're done. And I tell them to go home, don't think about the case, just take a load off and show up, the next day for the beginning of jury selection and opening arguments. That's another thing, is I am always careful not to prepare the clients or go over the testimony too far in advance. Because make no mistake, they are going to forget your instructions, no matter what you do. I don't care if you got out a tattoo gun and tattooed them on their hand, they are going to, halfway through their testimony or halfway through cross, they're gonna forget what you told them. But if you told it to them 2 weeks before, they're not even gonna have it with them when they get on the stand. So I think that's an important point too, especially with your clients, your critical witnesses that are, that you have the attorney-client relationship with, so you can, frankly explain to them what's gonna happen, what they need to do, and then, they get up there and hopefully don't completely screw the pooch. So that's just, what you're praying for.
And my goal with any witness is to have met with them twice before trial. I know sometimes you're not able to do that, but I like to try to meet with them twice before trial. I like to try to meet with them a month before trial, where I give them kind of a prep of, it looks like trial is still going, here's a copy of your deposition, you ought to review it before trial, here's what we're going in, and here's the theme of our case, and here's what we want to try to prove, here's what we want to try to establish. And I never make suggestions to them of how they can help me get there. I always just tell them what my theme is and what my presentation will be, and I let them figure out how they're going to fit into that. And in my mind, that is, to me, is the ethical way, I think, to do it. You don't want to coach them, you don't want to say, this is how you're going to answer. But at the same time, you don't want to just let them walk in and have free reign. So the middle ground that I like to use, that I've tried, that I think is successful for me anyway, is that I go in and I say, here's our theme. Here's what I want to explain to the jury. Here's what I want them to understand. And I do it in layman's terms. I don't do it in legal jargon because I don't want my witness to try to become a lawyer. I don't say, here's the elements I have to prove. I don't say anything like that. I say, here's my theme. My theme is about responsibility.
Well, yeah, and I guess I should clarify what I said. You don't want to explain to them all of the legalities, because the worst situation you can possibly get into is having your witness on the stand trying to play junior lawyer and figure out like what, when they get crossed, trying to figure out what each question means, or trying to figure out when you're asking them questions on direct, what you're trying to get at, or which part of the narrative are they supposed to pick up, and because they'll inevitably get confused and lost, and they'll look like they're searching for the truth to the jury, which obviously is bad, because my case is typically a huge amount of the likelihood of whether or not we're going to win depends on what the jury thinks of my clients, and especially how much we're going to win, what kind of a verdict we're going to see is going to depend on whether or not they believe my client, whether or not they like my client. And your clients will be vastly more likable if they can get up there and stand and just kind of speak from the heart. Now, where Patrick and I may disagree is I will tell my clients, like, okay, well, look, we're at trial. Now, if we're at trial, again, by this time we've gone over this multiple times. I mean, from the first time we've met, I'll explain to them, what negligence is, what the elements are, and what we have to prove in order to do it. We've gone over it as part of their depot prep, and then, as part of getting ready for trial, we're going to go over that as well, and we're going to talk about it, so that the clients understand what I'm getting at when I'm asking them questions. Because again, you don't have the kind of control that you have on cross, which is why direct examination just sucks. I mean, if I get a chance if I'm in charge of making assignments before trial, I always pawn off directs on whoever is my junior, because I hate them and I don't want to do them. I don't like them. I'd much rather, in fact, I tend to prefer Don't tell any of my opposing counsel if any of you happen to run into them. But I tend to prefer calling actually as my first witness. As a plaintiff, I tend to call the other side because I want to be able to go through what I need to prove or the narrative that I'm trying to, that supports the theme we have with the jury, and be able to say, okay, I already have before my client gets on the stand, I want to be able to say, I already have 95% of what I need from the opposing party, and then, by the time my client gets up, it's more about them connecting with the jury understanding the way they feel, helping the jury to see, okay, this person has, suffered these damages, so that when I get up in closing and say, I want, ladies and gentlemen of the jury, we would suggest, only you can determine what, should go on these particular lines, but here are the numbers that we would suggest, on the verdict form. That the jury won't be shocked, they won't think it's unreasonable, because they'll have already formed a kind of an emotional bond with the client. And that's a lot easier to do if I'm not sitting up there trying to check off, okay, did we show this? Did we show this? Did we show this? All of that's important, but again, I recently had a trial where it was odd. We had no opposing witnesses. The defense didn't call any witnesses, and they lost, but their clients just didn't really have anything relevant to say because they weren't there, they didn't see anything, and it was a strict liability case, so their conduct really wasn't relevant. But it was kind of weird to be in that situation where I couldn't get anything from the other side. And we'll talk about that more when we get to cross, but in my situation, plaintiffs have the burden on most issues, and so I feel entitled, I feel required to explain that to my client and to explain, all right, here is what we need to prove, and here are the parts of it that that we're getting from your testimony, as I have a copy of their transcript from their deposition sitting there in front of me. So, now I think it's a little different when you're talking about, if you're talking about preparing a witness that isn't your client, it's like a third-party witness, then you may get into a little bit more of a gray area explaining that. But realistically, when I've been hired to represent this person, they're entitled to the benefit of my expertise. I mean, that's what they're paying for, is my brain and my time. So, sitting back and saying, well, you testify to what you're going to testify to, and we'll see if it meets the standard, I think isn't really carrying my burden as the attorney.
And for background, for those who haven't been in the CLEs before, part of the reason why Gabe and I have paired up for this is because we have Gabe mostly does plaintiff work.
I do a good job, and Patrick still needs
He
me.
does the extortion side,
So-
I do the righteous side.
Yeah.
The last,
I'm the extorter, Patrick is the hostage taker, so.
The last three things that are just kind of common sense, but I don't think a lot of people think about when they're doing their witness preps. The other thing I always like, the reason why I like to meet with witnesses is not just to prepare them, but there's a human factor that goes into trial work too. And most of these people, if they've been deposed, have been deposed years before trial, and either have forgotten about the case, don't care about the case, or they're your client and obviously they care significantly about the case. But when you're talking about neutral parties, when you're talking about third parties, I always meet with them before trial too. Because one, they probably haven't thought about the case in a while. And two, more importantly that I think attorneys overlook, is I want them to like me. I want to be the face they recognize when they come into the courtroom.
That's a tall order.
It is a tall order.
That's tough.
But I do have my hair pretty.
That's why you meet with them twice, right?
What?
That's why you meet with them twice?
That's why I meet with them twice.
Get that extra.
So when they hated me the first time,
oomph
like
in there.
that other guy, that guy was.
Yeah, that was a different dude.
But if you think about this, this is a very intimidating circumstance for these witnesses. A lot of times they've never been in court, even if I have corporate clients, a lot of times they've never been in court. You want to be the friendly, familiar face in the courtroom. And maybe it doesn't make a whole lot of difference because like Gabe said, their testimony is pretty locked in. But trial testimony still is very loose and fast. And if you get that little bit of edge that they like you, they know me, they've met with me twice, they like me, I've been out to their house, and Gabe is a complete stranger, If they get backed into a corner, they can pick a side to side with, they're gonna go with me,
You mean the witnesses?
the witness.
So you're hoping that your clients will side with you?
No, my clients never side with me, they hate me.
They don't?
They hate me.
Okay, well, that makes sense.
The second thing is, I think it's especially for your own clients, is it's very important to explain the logistics of trial. To explain how everything's gonna sit. You're gonna sit here. You're going to be asked questions from me as much as you can without being awkward. Try to answer to the jury or try to answer to the judge. Don't look, try to have a conversation with just logistical things that they might not think about. Last month I was in a trial and talking about logistics. The other side brought in who was, in my opinion, their key expert witness. And he was a neuroradiologist, so he was a professional, he was very intelligent. He did actually a very good job on the stand. But when he came in, he was in a mismatching suit, his tie was undone and skewed to the side, his shirt was kind of untucked. And he came up and he sat down, and I just thought, this is your doctor, witness, expert, the guy who your whole case relies on. If it were me, I would have told him, you're a doctor, you're a professional, I need you to come in and look like that. You need to exude confidence and credibility.
Yeah, well, some of the most difficult witnesses to direct are actually those witnesses who are extremely intelligent but who are not professional witnesses. Because they inevitably find the subject of their testimony way more fascinating than everyone else. And so they will go on and on and on and on and on. I mean, I've had a lot more problems with those type of witnesses just talking too much rather than trying to coax out of them, what I need them to say. It's, how can I get them to shut up? And I've even seen, I was second chair in a trial where we had a client who was like this. Brilliant engineer, built several companies over the course of his life and, held several patents, new technology. And the senior attorney, it got to the point, he let him answer 2 or 3 questions. So we'd known this was gonna be a problem. We talked to the client about it, but he just could not, he had kind of diarrhea of the mouth a little bit. And he just couldn't stop himself from going on these tangents and explaining how amazing this technology he developed was. And the lawsuit was about, that technology and how we alleged that somebody else had taken it and not paid for it. And eventually, after 2 or 3 questions that went on, the answers should have been yes or no, and they actually went on for about 5-10 minutes apiece. A senior attorney said, okay, stop, and stop the guy right in the middle. Normally this would draw an objection from opposing counsel, or the judge would stand in, or the jury would be thrown off, but the look we got from everyone in the room was, thank you, please stop this person. And he said, okay, I'm gonna ask that question again, and I want you to answer it for me in less than 30 seconds. Go. And he asked him the question, and the witness was kind of like confused, but he's like, done. Okay, same thing, I'm gonna ask you this next question, you got 30 seconds. Boom. And he went on like that for probably half an hour through his entire direct, and nobody said boo. Nobody objected, nobody fought him on it, because everybody just wanted to see things moving forward, and it was painful to listen to this guy just, go on and on and on, and after about 2 minutes, nobody had any idea what he was talking about, because it was so esoteric, this area of knowledge that he was an expert in. And I think sometimes when you get witnesses like that, you will get a lot more leeway from everybody in the room, because it's obvious that, if you don't do this, they're gonna have to suffer. So, you can get away with a lot more.
And we put in the handouts, if you read through the handouts, but I'll remind you, Rule 611C is the catch-all for asking leading questions. It gives you a broad range of, you can ask leading questions if it will help make the trial more efficient, or if the witness needs it. So don't forget that we come out of law school knowing you gotta ask open-ended questions during direct, and you only ask leading questions during cross. Keep in mind the rules actually do allow for you to implement leading questions in your direct examination. And in my experience, if you do it selectively, And if you do it with the intention of speeding the process up, you won't get objections from the other side, and if you do, the judge will say, no, I think we can,
Well,
and you look
it goes-
like you're just trying to help speed it up, which the jury.
It goes back to the purpose of the rule. The purpose of the rule not allowing you to, and you'll see when we talk about cross-examination that leading questions are a godsend because it lets you effectively testify as counsel. And the rule doesn't allow you to use leading questions on direct because they don't, the drafters of the rules thought it would be a bad idea if we just turned it into a swearing contest between the attorneys, and the attorney gets up and testifies all the way through direct, and then the opposing attorney gets up and testifies all the way through cross, and then the jury has to decide who to believe. They want the witnesses to actually tell the story on direct. Now, without being able to ask leading questions on cross, you become very ineffective. I mean, it's almost impossible to do your job. And I can tell you that from experience because I've had a trial where a judge prohibited me from asking the opposing party leading questions on cross, and it was very painful. I think it went on for about 3 hours longer than it should have, and the judge kept interrupting me every third or fourth question, telling me to move on because he didn't like that I was leading the witness. So it was very painful. But the purpose of that rule, so long as what you're doing, asking leading questions on direct, serves the purpose of the rule, meaning you're not trying to get the witness's story in for them, you're just trying to move some uncontested stuff along, or if you have a child witness or a witness with a disability, mental disability, and they need, they're just not going to be able to testify without some leading questions, the judge is almost uniformly, they're going to let you do it. Because again, it serves the purpose of the rule. The rules don't just exist as a technicality.
All right, so we've talked about preparing your witness. Let's just talk briefly about how to prepare yourself for a direct examination. And for me, I think there's 2 or 3 key points I want to hit in this. The first is, and I'm surprised how many attorneys are bad at this, is think about the order in which you want to present your evidence. We talk about when you're at trial, you're building a brick wall, and there are multiple bricks that go into this brick wall, and unfortunately, you don't get all the bricks from one source. You have to have some bricks from this person. You have to have some bricks from this witness. You have to have some bricks from this exhibit. And so you're piece by piece putting your bricks together to make this wall. Think about the order you want to introduce those bricks. Think about who are your strong witnesses. Think about who are your weak witnesses. You always start strong, end strong. Even in direct, you can manipulate your questioning to make sure that you start strong and end strong with each witness.
Well, and remember, what it is you're really doing when you're trying a case is you're engaging a group of people, the jury, with competing lessons, with competing teaching styles, competing stories. It's almost like you were in a high school English class, and one teacher got up and taught a lesson, and the other teacher got up and taught another point of view, and then the class at the end had to vote who they believed. And the reality is that the jury will tend to make up their mind. First of all, they tend to make up their mind very early in the process, and they tend to go with whichever story they believe. And if we look back through human history, what is the earliest type of teaching that we see? Well, it's storytelling. It's oral history. It's the ability to be able to get up and tell a coherent narrative that illustrates some key points. And so when you're putting together your order of your witnesses, it oftentimes is helpful, and I will actually make a storyboard that shows, okay, first this happened, and this happened, and this happened, or if I need to take things out of order, I will, so okay, here is the critical event, and then here is some background, and arrange it so that it's in sort of a convenient format. Like if you were going to tell a story to a 5-year-old, how would you go about it? Well, you wouldn't pick the witnesses based on just the order that was most convenient for them to show up in court, right? I mean, you wouldn't tell Hansel and Gretel by saying, okay, well, I only have a witness to the witch part who can testify at the first, And then the woodsman is only available at the end, so I'm going to tell about the kids in the witch's house, and then later on we're going to get to, at the end, we're going to get to why they were in the forest in the first place. Nobody's going to understand that, and they're certainly not going to get it better than if, you know, your opponent has a much more cohesive narrative. Then that's just it's going to sit better in people's brains. There's been a lot of research done going back to the 60s about mythic structure and the structure of early storytelling, which is why a lot of times when you're watching a movie and you're enjoying it, it often seems really familiar, or you can kind of tell which character is going to do what next. And you know, this is the way, you know, screenwriters have been using it for, you know, for decades about you know, how to put together a cohesive story. The early Star Wars movies were written exactly to follow this this mystic structure. A guy named, I believe it was Joseph Campbell, right? It's called a book called The Hero with a Thousand Faces, and it talks about this structure. And you know, Raiders of the Lost Ark was written. You know, George Lucas used this process extensively when he was writing all these movies, and that's why the movies tend to work and tend to kind of go together really well. And you know, the narrative's really easy to follow. And you look at some other stuff that deviates a lot from that. You know, those are the movies you can sit through and you're kind of like, I can't get into this, or I can't, you know, I can't seem to follow this, or this element of it doesn't make sense. It's because the story is probably deviating from this normal pattern that we're used to. Because you look at, you know, ancient Greek myths, Norse myths, from all over the world, follows the same structure. And so you want to be able to find a way that you can tell this narrative in a coherent way that the jury will relate to and that will intrinsically seem familiar to them. Somebody described it to me once as you want to convince the jury that your side is arguing for something that they already believe in. You're not trying to convince them of something new. You're trying to convince them that your client's position fits in with preconceived notions and ideas that they already hold, and which is a lot easier than trying to convince somebody of something brand new. And one of the ways you do that is structure and order. It also makes you look a lot more organized to the jury, and you know, they obviously appreciate that, and they take it every time we've polled or we've asked jurors afterwards what was, you know, key in their decision. Whether they know it or not, they'll wind up referencing something that is the equivalent of, well, the attorneys on this side seemed very prepared and organized, and their story made sense, whereas the other sides did.
And that I'll pick up where Gabe is leaving off. That's the second cardinal sin that I see in lack of preparation from attorneys. The first is not knowing what order you want to present your bricks in. The second is know how to tell your story. Too many attorneys fall back onto going, let's start at the beginning, what happened next, what happened next, what happened next. And that's how they direct their direct examination. And maybe that works in some cases. Maybe that's the appropriate way to do it in some cases. But we're paid the big bucks to think about the story, and as Gabe said, tell it in a very compelling way. Some of the most impressive trials I've been in is when they have the plaintiff get up, and the first thing they ask the plaintiff is something like, why are you here today? Why are you suing today? And they start right, instead of talking about the accident or whatever that hurt them, they say, my life has just been ruined. I can't do this, I can't do that. They start in the middle of the story. And then the attorney skillfully goes back to, okay, well, let's talk about how you got there. And then we'll talk about the accident or whatever. So think about your story and think about the compelling way to tell it. And usually, sorry Siri, usually it is not in the chronological narrative order. That is usually not the most persuasive way to tell your story. The second thing that related to that, don't just try to recreate the deposition. This is something that's just dawned on me in the last maybe 4 or 5 trials I've done, is that inexperienced attorneys try too hard to recreate the deposition. And instead of asking questions about, so, you know, tell me about what happened next, they're saying, okay, but then you remember being deposed in your deposition, you said this, right? And they're basically, they're using the deposition as a crutch.
Well,
And they're trying to recreate that deposition rather than pull out compelling live testimony.
And one of the reasons why attorneys will do this, and is because, and we'll get to this a little more when we're talking about cross. We're talking a little bit about impeachment, but a lot of attorneys, their understanding of how to deal with opposing witnesses pretty much ends at impeachment by prior and consistent statement. And the reason is because in evidence class in law school, this was pretty much the only rule on impeachment that was straightforward and that we understood, and then we all got, oh, the witness said one thing one time, something else the other time. But then, you know, you can't rely on that. Again, for reasons we'll go over when we get to it, but, and there's a right way and a wrong way to go about it. But certainly when you're on direct, trying to, you know, tie your own witnesses down to their deposition doesn't make any sense. Although I've seen, like Patrick said, I've seen lawyers do this. Now, I will put in this caveat that one thing, and we've advised this when we do the depositions class, is that it's really not that helpful to have two different styles of cross-examination. It's not helpful to have a depo style of questioning and the trial style, because it's really hard to keep two different styles in mind and then deploy them selectively. You're going to wind up finding one style more comfortable and then falling back into that when you get stressed, which you will at trial. So, you know, I tend to take depositions for the most part. Once I have an understanding of the landscape and what the case is about, I tend to take depositions the way I would cross-examine. And so eventually there'll be at least a section of the deposition that really is the questions that I'm gonna ask verbatim almost at trial for a very good reason, which again, we'll go over when we get to impeachment. But yeah.
And let me give you an example from the last the trial I had last month, the one that stuck out to me. Plaintiff was up and he was deposed, he was examining his witness, and he said, and did you talk to the manager about this particular venting for this boiler? And he said, yes, I did. I got the information for him, I put it together, I gave it to him. All right, and then in your deposition, you said you talked to him a second time, didn't you? And again, trying to recreate the deposition, we get paid too much money to regurgitate what's already happened.
And technically that is objectionable,
Sure.
because the deposition or the fact of the deposition is only admissible to the extent you're using it for a purpose that is allowed at trial. Now there is some disagreement with regard to 30b-6 depositions because the rule says they can be used for any purpose. Patrick has had the joy of having them put on and just played for the jury, which decimated his clients, although they were destined in this case anyway. But still, and that's kind of
my guy has been deposed for 14 hours, and by the end of his deposition, he's just sitting with his hands.
Which I'm
in his
still
face like this.
shocked that you allowed that to happen. How did you? When there were 7 hours per witness, man. You could just say.
He was called as a 30b-6 and then as a fact witness, and we fought it, and the judge said he could come back.
Yeah, well, I
And
think
so
still.
at the end of 14 hours, he's sitting like
Somehow
this.
you were involved in that.
And then they
mistake.
splashed that up during his testimony, just showing him, you know, it was bad. We fought it, we lost.
Yeah.
But thinking back about why, especially more inexperienced attorneys, try to recreate that deposition so desperately rather than just pretend like we're starting over, but you know what the answers are, and so you're asking questions to elicit those answers, is again, it goes back to that control, right? Of that they think, okay, I know it played out this way in the deposition, I just want to recreate that and redo that. Don't do that. It's very ineffective. You ask a question that says, now in your deposition you said this or this or this. The jury doesn't even hear your question because they're thinking, what's a deposition?
Well,
and why don't I get to see that? What's you know, there's information out there I don't have, and they completely miss your question, they miss your answer. So just don't do that.
And it comes back to something we've emphasized before, that, you know, as a young attorney or an attorney who's trying a case for the first few times, one of the things that you're going to try and do is you get so nervous and you want to do a good job and you don't want to screw it up. Rather than wanting to do a good job so much, you just don't want to screw it up. You don't want the client to be able to say, you screwed up my trial, or the partner to say, you ruined this, you know, it's your fault. And so you try and you get this idea that, well, I got it on the record, or I got it into evidence. And, you know, maybe if you're thinking about saying, well, I'll tie it up on closing, okay? Problems with that. First of all, getting it in the record is meaningless. If the jury does not understand a fact and its significance in terms of the whole case and the whole story, the jury will ignore or forget that fact. They just won't hear it. Has anybody ever done the experiment when you go online and you watch the video, and it's a basketball team passing the ball back and forth, and they tell you to try and count how many times they pass the basketball? Who here has ever seen this video?
Is that where there's a black bear in there?
Gorilla.
Yeah, there's a gorilla. There's a guy in a gorilla suit that comes out and runs around. And if you're just trying to focus on passing how many times they pass the ball, you do not see the gorilla. And that's your jury, okay? If something is not in context, if they don't understand what they're looking for, and you don't give it to them, they're not gonna see it. They're not gonna hear it. And so getting it in the record, you know, the appellate lawyers will want to burn me in effigy in the back parking lot. That's fine. But for purposes of trial, getting it on the record doesn't matter. It's getting it to the jury, getting it in their minds, getting them to understand, to hear you, understand you, and to assimilate that information. And if you don't do it in a persuasive way, you're not going to be successful at that. It's going to go right over their heads, and they're going to be thinking about something else. And if you're just, you know, going through the depo and saying, remember in your depo when you said this? Okay, remember in your depo you said this. First of all, you might draw objections and have to deal with the judge on it. And second, you're just not going to retain the jury's interest for very long. The other thing I want to say is that this idea of I'll tie it up in closing, or I've got it in evidence so now I can argue it in closing. Every study that I've ever seen or heard about studying when jurors make up their minds, it's almost certainly, probably 90% of your jurors have basically made up their mind which way they're going to vote by the time you're done with opening statements. Certainly by the time the first witness has been sworn and testified and been crossed, they've got a pretty good idea. Some jurors might be able to be persuaded one way or the other, but no matter how many instructions the judge gives them about not making up their minds, it's just not possible for a human being to do that. You can't. You're gonna form opinions. And so if you're waiting until closing to make key points, crucial points in your case, you've waited too long. Your jurors have already decided. Closing is mostly about pulling your arguments together and giving those jurors who are already on your side at that point the arguments that they will need back in the jury room in order to convince other jurors, or to box them in and get them to change their votes if there aren't enough for a verdict when they walk in there. But it's not for presenting arguments for the first time to a jury, because it's incredibly ineffective at doing that.
So let's talk. I've been trying to figure out for years how to get people to ignore the gorilla in the room. Maybe I need a basketball so people will be passing. Let's talk about now execution.
We're big, but we're stealthy.
Let's talk about execution, some execution tips, and specifically you'll notice as I go through some of these execution tips, you'll notice all of them come back to that element of control. These are little tips and tricks to be able to maintain some kind of control in a direct examination and don't let it run away. The number one tip that I have, and this actually works for direct and cross-examination, and honestly, it's a comfort thing. You see younger attorneys, more inexperienced attorneys not do this just because they're not comfortable doing it. They don't know that they can do it. They think they're going to get objections to it. And that's using narrative transitions or introductions to your questions. You've got your witness up there and you say, okay, to start, I want to talk a little bit about this. Let's talk about that. Is that all right? And then get into your question. Right there, I think young attorneys think, I can't do that. That sounds like leading, or that sounds like I'm testifying. I'm not allowed to talk that much. It has to be a what happened next question. The attorneys that can effectively use introductions and transitions, it does two things. It controls your witness, because now your witness is focused, okay, he just wants me to talk about this. But it also keeps your jury along with you. It helps your jury see when you're moving from thing to thing, and they keep up with you. We'll talk about.
They don't get as bored, and it's a lot like kind of what I saw Neil Gaiman, the writer of the mystery books. He wrote American Gods and a bunch of other things. He says the most important things for a storyteller or writer to hear from their audiences, and then what happened. What happened next, and being able to put those transitions in there, saying, okay, now we're going to talk about what happened when you came to the house. That helps keep the jury engaged and on track with the story. And I've never seen an objection.
Never.
I can't imagine one ever being sustained, but I've never even seen an objection to that. Because it just simply makes things go smoother, faster, and more organized. Yeah.
This is usually a topic we bring up in the cross-examination, but one of our idols, Roger Dodd, who's an excellent cross-examiner that goes around teaching around the country. One of the things I remember him teaching that was very impactful: if you ever want something to get in, make it interesting and or fast. Even if it's objectionable, even if the objection should be sustained, if you tell the judge, I'll be really quick, the judge will always let you do it. Or if it's interesting enough, the judge will say, I want to hear what's next.
Yeah, like, no, we're going to let that come in. Yeah.
And then the converse is true. If you want something to be held out, make it long and make it boring, and it'll get thrown out. So when you do these transitions, these introductions, judges will always let them in because they're making the process more efficient. They're keeping everyone's attention. There's nothing really objectionable about it.
I've never even seen it. I've never seen opposing counsel even try.
So use your introductions and use your transitions. The second that I think is very important, and you might know this, is address your warts. Don't sit on the time bombs and wait for the other side to bring them up. And do it in a very skeptical, constructive way. And this goes back again to prepping your witness. You let your witness know, we have this wart, we have this issue, I'm going to ask you about it. And I'm going to ask you about it in a very skeptical way, because I want you to be able to explain it away to me and to the jury.
Well, and hopefully the jury has already heard the few pieces of information that's bad on your side in your opening.
Right.
And so now you're giving the witness a chance to explain, okay, here's why, yes, that sounds bad, but it's not, it's not as problematic as you might think.
Right. And this goes, we have this debate in our office sometimes about motion work, right? If you're filing a motion for summary judgment, you sit there and you think, okay, well, their opposition to my motion is going to be this argument and this argument. Do I tackle it in my motion, or do I wait for them to make it in their opposition and then tackle it in my reply? Because then if they're not smart enough to think about it in their opposition, I don't give them a roadmap to how they should try to defeat my motion. All of that's out the window at trial. At trial, if you've got bad problems, if you've got bad issues, you raise them. Because you're raising them within the context where now you have control of the discussion. You have control of where it's going to go. Then when the other side gets up and tries to make this big, aha, but what about this? You've already talked about it. And all the dog and pony show is gone. And your witness can say, well, yeah, we've already talked about that. Remember I said it was because of this, and it just deflates the other side's argument.
Yeah, and if the other attorney brings it up and they cover the same ground, the jury's gonna be like, okay, yes, boring, move on. Boo, sit down, we're done with you. We wanna go home, we're tired, we're hungry, we didn't ask to be here. Shut up, go away. Yeah.
The other key point is start strong and end strong. We always think about this in cross-examination because we think we can control it by asking very pointed questions, and we can come up with humdinger of questions to end on. You can do this in direct examination too, and you should do this in direct examination too. I cannot understand how many times I've seen the other side doing a direct examination of a key witness I object about something, it's sustained, and their next reaction is, no further questions here.
Oh.
And they leave just deflated, and no, you start strong, you end strong. We talked about, don't go chronologically, have topics, and go from topic to, and construct your story so it's thematic, that it follows your theme and tells your story. Have a strong topic to start with, and have a strong topic to end with. Don't ever fizzle out when you're doing your direct
You don't wanna do your direct where you're asking them about, okay, and then, after you flew through the windshield, what was it like? Oh, there was blood streaming everywhere, and then I was in so much pain, and then you end by asking, 10 questions about, all right, so, did they take your wallet and your keys in a bag with you to the hospital? Or did they, was it a blue gown they had you wear? Okay, all right, well, we're done. And the jury just like, wah, wah. I mean, it really, you waste so much of that impact. They talk about importance, and there's a lot of concepts we can't really cover even in these 2 hours. I know you guys feel the same way we do. We'd love to be here all day, just talking about trial all day long. Yes, but we only got 2 hours. But primacy and recency, very important in order to emphasize your points. What you ask about first and what you asked about last are more likely to stay with the jury. Okay, and so don't spend all that energy and all of that persuasive power banding on something that doesn't matter. I mean, really, if it's not important or if it's irrelevant, you're just going to leave the jury, thinking, what was the point of that whole exercise? Even if you spent all the time in the middle on stuff that was really relevant and critical, they're going to be focused on what you talked about last and what you opened with. Again, it's one of the reasons why I like to call opposing parties first and get them to cop to about half to 3/4 of my client's theory of the case before I get into directing my own witnesses, because the jury will remember that. The other side agrees with most of what he's trying to tell us, so we should probably accept that as true.
And I'll challenge you to even think about that for breaks. Try to end strong before a break. If you're gonna have a witness that goes into the next day, that you're gonna take an 1.5 hour lunch break and they're coming back on the stand after lunch, try to end strong before the break. Every time the jury leaves your site, leave them with something to think about. Don't leave them on a down note, all right? One last tip, and again, you'll see that it all boils down to control again. We're gonna talk about this on cross-examination. One of the cardinal rules of cross-examination is only one new fact per question. Again, you've been living with this case for 7 years, whatever, you know it inside and out. This is the first time the jury's hearing it. The rate at which they can absorb the information is very, very small. So you give them one new fact per question. And how does this work in direct? Because in direct, you can't ask leading questions. If your client muddles together a bunch of very, very important facts within one response, don't let them get away with it. Stop them and break it down. You go back to your transitions, your introduction. Now hold on, you said a lot of important things in that answer. I wanna go back and I wanna talk about it a little bit.
Let's break that down.
Let's break that down.
Yeah.
And you go back and you make them highlight fact by fact the important stuff. Don't let them mush the whole story together and then say, well, it's all on the record, so I'm good. All right? Remember what you're trying to accomplish here. You're trying to make sure the jury understands your story and sympathizes with your story and understands the righteousness of your story.
And just to keep in mind something I said earlier about appeals and appellate lawyers will crucify you for not getting something in the record, but the reality is that cases are very rarely overturned. Verdicts are very rarely overturned because of fact or evidentiary issues, and the burden for getting something overturned on something like that is really high. You're so much better off just winning at trial. Then you don't have to worry about the appellate issues. It's great. You just win them in the beginning. I think it was Happy Gilmore, the old thing. He doesn't know anything about golf, and he comes and he hits a hole-in-one, on like a par 4 or something. And he says, gee, that's a lot easier than putting. I think I'm just gonna do that every time. I mean, and that's kind of a facetious example, but that should be our goal. Is like, you know, appeals are for when we lose and when life sucks. We want life to be awesome, and so we want to win. So we're going to focus on trial.
All right. Let's take a quick break. When we come back, we'll talk about cross-examination.
The best thing in the world. Now we're going to talk about the best part of trial, the only part that rivals it, maybe closing. It's cross-examination, okay? And I'll tell you why I love cross-examination and why I think direct examination is stupid. Cross-examination is an opportunity for the lawyer to testify. You know, we've always seen lawyers on TV, you know, get up there and they'll give a long speech and then somebody will jump up and say, "Objection, Your Honor, the lawyer's testifying." And that's always funny to me because if cross-examination is done right, that's precisely what you're going to do. I mean, the goal should be to get the witness to say one word as many times as you can, and that word is yes. Okay? And if the witness does not say the word yes, then we punish him until the witness learns that he or she will not look so much like an asshole if they say yes. And that every time they don't say yes, they're going to suffer. And eventually they will learn to the point where you will get a witness who will get into the zone where they're just kind of looking out and saying yes, 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 yes. Like they're one of those little birds that drinks from the cup. Yes, yes, over and over again. Because they've been taught appropriately to say yes. Now, how do we teach the witness to do this? What are the keys for a successful cross-examination? Well, there's a couple of really critical tools you need to have in your toolbox. First, logic, okay? We're going to talk about how to do an effective impeachment, but the most powerful impeachment that you can have is live impeachment, where you get up after the witness has told their story and you get up there and you just decimate them. And I'll say in advance that all of this will only work if what you're trying to get the witness to say is true. Because only the truth is really logical, okay? And the only way you can get the witness to say yes, unless it's something that they're willing to admit to or they agree with, is to put them in a position where they say, okay, you know, they're up on the stand, they're already nervous because everybody who's in the courtroom, who's not in the courtroom every single day, is nervous. And, you know, everybody's looking at them. And in this moment, you've got to put them in a position where they have to say, okay, I can tell the lie or, you know, shade the truth in the way that helps my case. But if I do that, based on the questions that I'm being asked, I am going to look like I'm an idiot or like a liar. And either one of those is going to make me feel super uncomfortable because I'm going to look over at the jury and I'm going to see every single one of them looking at me going, you're an idiot or you're a liar. And the social pressure that comes behind that is incredibly powerful. And it only increases, this is one of the few situations where your ability to do something at trial only increases as the witness gets more experienced. Expert witnesses can be just devastated if you use these techniques correctly, because they not only have the normal pressures of not wanting to feel uncomfortable in front of other people, they also make their living based on their ability to give good testimony. And, you know, I can't tell you how many experts get, you know, their careers significantly affected or torpedoed by one or two really bad appearances where the jury either just completely discounted their testimony or where they were disallowed by the judge for one reason or another. So, how do we put the witnesses in this? Now, Patrick, for some reason, I suggest laziness rather than incompetence, because he's a smart guy, has put in here Irving Younger's,
think that was a compliment.
from a relative standpoint, yes, has put in Irving Younger's 10 Commandments of Cross-Examination into your handout. I don't know why we do this, because while these are good advice, they're incredibly difficult to implement. Okay, and the cross-examiner whose temple Patrick and I pray at, Roger Dodd, I once heard him say that he actually got a chance to talk to Irving Younger about this a few months before he died, and asked him why 10 rules. He said as far as he could come up with, there were only really 7. And Irving Younger said to him, well, there's really only 6, but 10 sells. And if you ever get a chance to go to one of Roger Dodd or Larry Posner's seminars on cross-examination, it's worth every penny, because it is, and their textbook, which is about this thick, is I mean, I guess I'm a trial nerd, but for me it's fascinating reading, because there's some really great stuff in there. But ultimately, the art of powerful cross-examination boils down to 3 rules, okay? And if you can remember these 3 things and execute them correctly, you will have witnesses in the palm of your hand. You'll be able to get them, witnesses who don't want to admit things that are harmful to their case, to gladly admit it, okay? First, leading questions only, right? Second, 1 fact per question, 1 new fact per question. And third, logical sequence leading to a specific goal, okay? Now let's talk about those a little bit. First, leading questions only. What is a leading question? There is an audience participation component to this course, so feel free to chime in whenever you like.
The question that provides the answer.
Question that, or at least suggests the answer, right?
Suggests the
Exactly. Now that's a traditional definition of a leading question, but for our purposes, that's not good enough, okay? A leading question is in fact a statement, okay? And the properties we talked about before about primacy and recency apply here. Okay? We don't want to add anything else to our questions that wastes the power of primacy or recency, okay? So we say, all right, you were driving down 300 South, okay? You were driving, yes. Down 300 South, yes. Heading east, yes. We don't want to say heading east, isn't that so? Or is that right at the end? Because those words are unnecessary. Who here thinks when I say, so you were driving, that's not a question? You will get this objection sometimes from the other side, occasionally from a judge who's well-meaning and says, well, that's not really a question. Reality is everybody in the room understands it's a question, including the witness, including the jury. And the few times I've gotten a judge to say something, well, counsel, you need to make those into questions, not just statements. I will ask, my next 2 or 3 questions will be, and you got in the car, isn't that so? And then you drove down the street, isn't that so? And after I do that 3 or 4 times, everybody gets bored of it and they understand, okay, these are obviously questions, we understand. And then I can drop it and nobody says anything. Nobody objects, the other side doesn't object again. Because, when choosing your objections, we've talked about this before, you don't want to come off bad to the jury. When the jury is engaged, they're hearing the story, they want to hear the story, and you keep jumping up with procedural objections, you're going to do yourself more harm than good. Okay, so we want to ask those leading questions that are really statements. Now, what happens if you get up there and you walk the witness through the testimony just by giving statements and getting them to agree with them? Okay, who's really testifying? The lawyer is. The witness is just agreeing with you. Okay, and that is basically the rule is you need to make statements that the witness can answer with a yes, and then let's talk about that second rule. One new fact per question. What happens if I start to combine a bunch of facts into a question? Especially if I've got a really weaselly witness who doesn't want to say what I say. Yes?
They can start to narrate.
Yeah, they can start to narrate, or they can agree with me, and then when their counsel gets up to redirect, they can say, did you mean this? Oh, no, I was saying yes to the other part of his question. He asked, did I throw the red ball to Susie? I threw the red ball, but I threw it to Sam, not Susie. And so it gives them a really easy out. And even for the jury, even if the other side doesn't do it, the jury may become confused because they may not be sure what exactly the witness is agreeing with, okay? And it's a lot easier for them to weasel that way. So you'd be like, okay, so you threw the ball. Yes. You threw the red ball. Yes. You threw the red ball to Susie. Yes. You threw the red ball to Susie and then she fell down. Yes.
That's what I meant by the narration, is because when you get a four-part question like that, somebody's gonna respond to, well, you're kind of correct, but, and then they're gonna go on to explain, and now you've lost.
Yeah, I mean, you could wind up with either problem. Either they narrate, they go on, and you're off on a tangent, or they just say yes or no, and you don't have any idea which part of the question they just said yes or no to. Neither does the jury. And you know, unless if you do it over and over, it really waters down your ability to commit the witness to the story. Now, when we talk about logical sequence leading to a specific goal, what does that mean? Well, you will organize your cross-examination into, a good word for it is chapters, okay? And each chapter will be headed by something that you want the jury to, a crucial element of the story, okay? An important building block of what, of your case. And it usually is something simple. And then I'll either write that at the top or bottom of the page, and then I will write questions in that format that are leading questions, extremely leading, and that are, have one fact per question, and that each one builds upon the last one, exactly like I was saying before. Okay, you had a ball, yes. You threw the ball, yes. You threw the ball to Susie, yes. Susie caught the ball, yes. You threw the ball to Susie, she caught it, and she fell down, yes. Okay, so now we have, he threw the ball to Susie, she fell down, okay? If you have enough of those, and you build your logical chain correctly, your syllogism correctly, what happens when opposing counsel gets up to redirect that witness? Well, he or she now doesn't have to just change one yes into a no, because if they just change the final yes into a no, then it doesn't make sense, because all of the other facts lead directly to the conclusion that you're wanting the jury to draw. So they get up there, and you want to put them in the position that if they're going to convince the jury that what the witness didn't mean what they said, or that in fact the opposite is true, they're going to have to undo now 10 yeses, not just one, right? And that's extremely difficult to do. I would argue, if you've done it right, it's impossible in a way that's convincing. I mean, can they, opposing counsel sometimes walk a witness through something like, well, yes, okay, all of that is true, but da-da-da-da-da. Sure, but is it believable to the jury when they've already heard, okay, A, B, C, D, E, boom. And then you have your answer, okay? And so I will put, and I'll start this in as we've talked about, the process of trial begins on the first day when you get the case. When the client walks into the office and tells you the story, you figure out who the players are, okay, what all the various parts are, what role they play in the story, and what information they have for the jury. And you lay out, all right, here's the theme. This is the theme of the story that we're going to tell. This is what it's kind of like, what's the play about, right? I mean, before you sit down to write, if you're a playwright, you need to at least, when you sit down to write a play, you need to at least have some idea of what the play is going to be about, fundamentally. What point are you trying to make? All right? It's the same sort of idea. So you sit down in depositions and you establish this. And you go through, and I'll do the same thing in depositions. Again, occasionally you'll have at the beginning of depositions, especially at the beginning of the case, where you may not have a sense of the landscape yet. You may not know who all the players are, because your client may not know. And so you're going to be asking these broad questions. Then, as we talked about in the deposition CLE, you start to narrow things down. By the end of the depo, I'm doing exactly what I'm going to be doing at trial. I'm saying, okay, and then this happened, yes, and then this happened, yes, and then this happened. And it becomes particularly important when you get to attempting to impeach a witness, or when you're trying to prepare for trial, understanding what are those building blocks, what are those facts that necessarily make the conclusion you're trying to get the jury to reach to be absolutely true, okay? Now, I am not a very big believer in, I think there are two schools of thought with regard to litigation in general and with this subject in particular, which is, there's a school of thought that says, we don't want to bring this up in deposition because we don't want to show our hand. We don't want the other side to know where we're coming from. I think, and this is just my opinion, Patrick may disagree, but I think this is an attitude that's more prevalent on the defense side of the case. Why? Well, on the plaintiff side, typically, as I've said before, these cases are a major investment for me. And, I make my daily bread based on how well the cases do and whether they settle, whether we get a verdict, whatever happens. And so I don't want to bet on a lame horse. I don't want to go in there and have to try and win this trial where I know that if all the facts came out, I should lose. And occasionally you wind up in that position because you don't understand everything, the client doesn't explain it very well, or you discover something the client didn't know and it's too far along to be able to change track, so you just have to do the best you can. But generally that is the worst position I ever want to be in. For me, the courtroom is the temple of truth. I mean, I want to be able to lay all my cards out on the table and make it very clear, even going into trial and then at trial, exactly what our case is, exactly what the witnesses are going to say. Most of the time I would be absolutely fine handing a copy of my outline for a witness examination to opposing counsel, because they should already know what questions I'm going to ask anyway. They should be aware, because I've already asked them in the depositions. My motions practice has been based around these same questions, these same concepts. And generally, I've got the key questions have already been laid out verbatim in some format, in an interrogatory or in a request for admission or in depositions. I've asked almost verbatim. And that, again, that becomes very crucial when you get to trying to impeach a witness. Because again, you've got your witnesses when you've got them on the stand and they know you're coming, they see you, and a lot of times they're way more nervous when you get up to cross-examine them than when their lawyer is asking them questions, and they're very wary about what you're asking them. And so asking them these little short questions with one fact in them per question can kind of put them at ease, but also help them understand that they are no longer in control of what we talk about. And we'll talk about in a minute, in a little bit, some techniques for dealing with witnesses that don't want to go along with the plan, or I call it negative reinforcement.
So Gabe's laid out the three fundamental rules, right? The way you conducted cross-examination. He's also mentioned the importance of having your theme. Now, let's take those and how do you implement those into the cross-examination? I want to talk about something that actually really evolved my cross-examination over the last few years. And that's the difference between a constructive cross-examination and a destructive cross-examination. Has anybody ever heard these two terms talked about examination? The theory of it, I don't know about you, but when I came out, my thought was cross-examination is almost always destructive. You're just destroying the other side, you're punching holes in everything they say. The more effective attorney actually uses cross-examination as a chance to do constructive work for their case rather than destructive work for the other case. The theory is their people, their paper, our theory. You use their people, their witnesses, you use their exhibits, their paper to establish your theme. The way to think about this is the analogy of Coke and Pepsi. Back in the 80s, Coke decided to start a campaign where they would make fun of Pepsi in all of their commercials and all of their advertisements. And what was the result? Coke sales went up, but guess who else's sales went up? Pepsi, because they kept mentioning them. So Coke decided, we're never going to mention Pepsi again. We are only going to talk about Coke. That's what your cross-examination should be if you can make it that way. Don't talk about their case. Don't talk about their themes. Don't punch holes in it. Use their people to talk about your case and your theme.
And I'll say this, elements of destructive and constructive across, you're usually going to use a little bit of both. I mean, if I can point out, it depends on the individual witness. Certainly if there's any way that I can attack the credibility of one of their major witnesses, if I can show that their major witness is fabricating or is shading the truth or is exaggerating, and this is a strategy on both sides. I mean, I've heard defense counsel tell me once, we were sitting in an airport, and not Patrick, another lawyer, he was telling me about a trial he had to go to the week after, and he said, they're really good. He's like, he's like, I told my insurer that pretty much the only chance we have is this witness gets up and lies, or this plaintiff gets up and lies or exaggerates, and then we've got an argument. Otherwise, if they just get up and tell the truth, we're screwed. Because if the witness just lays it out there and the jury believes the plaintiff, then usually you're going to win. Now, if I have something where I can say, okay, well, you testified to this, but in fact, this, and this are true, and those facts are inconsistent with what they testified to before, I don't even have to point it out to them, okay? I mean, and that should be one of your goals, is that, now Irving Younger put it as, don't ask one question too many. And I've always thought that, ever since I first heard that, I always thought that was hilarious, because the only time you ever know when you've asked one question too many is when you do it, okay? And then it's out. There's no way to pull those words back in. One way to tell, if you're gonna do it, a couple of things. First, it usually happens when you're just really kicking ass and you're up there and you're feeling so good and the adrenaline's coursing through your veins and you're just like, man, oh man, I got this. All right, let me ask him another question. And I hit the end of my outline and I'm like, shit, let's keep going. I'm loving this. This is great. And I just keep asking questions. That's when I'm gonna get myself into trouble. Mike Tyson once said, if you're not humble, life will visit humbleness upon you. And you'll have one of these moments if you ever use, Larry Posner described them as one of the 7 enemy words, okay? That you never, ever want to use on cross-examination for any reason. Who, what, when, where, why, how, or the worst one in the world, does anybody know what it is? Explain. Oh, never asked explain. Never. Anybody here ever seen John Travolta in A Civil Action? Okay, so he gets this witness up here, and it's this, he's played by, I can't remember the name of the character actor. He's a genius. He's in so many films, but he's a guy that runs this tannery where they've been just wholesale dumping these horrible chemicals into the groundwater for years, to the point where, some of you read the book where there was a pond or a river behind the factory that actually became flammable and exploded at one point. So, and he asked the guy, and just kind of a throwaway question at the end of his examination, well, explain how you could care about this land if you did this so much. And this is this concept you'll hear a lot of times for older attorneys, never ask a question that you don't know the answer to unless there just is no good answer, okay? And I am here to tell you that you may think that you are asking a question to which there is no good answer, but if you ask that witness that question, you are about to hear what that good answer is. Because you're asking somebody who's been sitting up nights for weeks or months thinking about this trial and thinking about this one key issue, and I promise you, they have come up with something to say if you ask him that question. And Travolta asked him this question, and he goes on this long soliloquy about how his ancestors had lived on this land and how it was, it was tied up with his soul. And Travolta tries to stop him, but the judge says, look, you asked him to explain. He's explaining. What do you want me to do? And that's what the judge will tell you if you are dumb enough to use one of those words. Never use those words on cross-examination, because you don't want their explanation. You don't want them to say how it happened or why it happened. You want them to say one word. Yes, that's it. That's all you need. You need a machine that will say the word yes over and over and over and over again. Okay? So why would you ask that machine to explain anything? You don't want them to explain. You're explaining. That's your job. You're picking the words that you're going to use throughout your trial as part of your trial strategy. You should be doing this. Once you figure out your theme early on in the case, you're going to start thinking of ways to describe things that happened, that use descriptive language, that use imagery that is helpful to your case. Okay, so the plaintiff did not go through the windshield. The plaintiff was hurled through the windshield. The plaintiff was thrown through the windshield. The plaintiff sailed through the windshield. Okay, I don't want to ask the witness for what his or her word is for it, the defendant, because they're going to say something that's not helpful to me. Okay? I want to pick the words. Why would I let some idiot whose goal at trial is completely opposite to mine, why would I say to that witness, here you go, you pick the words you want to tell the jury to describe this, you take over, and you explain to the jury my theory of the case. I mean, they didn't go to law school, they don't understand, and they don't have your client's best interest at heart. This is one of the reasons why you're being paid, is because you are an expert in this craft of storytelling, of being convincing, being persuasive, being able to select the words and the emotions and the pictures to paint to the jury. Why would you hand away that power to your enemy?
And in my mind, this is next level lawyering when you start talking about wordsmithing. You're trying to pick words before trial that go into your theme. You're trying to pick words that already come preloaded with biases, with meaning within it. But when you say the word, you're already invoking emotion by the jury. And this isn't just a jury trial, this is when you're drafting your motions, this is when you're doing depositions. You're trying to pick words that by using one simple word, you make 10 arguments with it. Because everybody comes preloaded with the reactions to that specific word and what they think about that specific word, whether it's got a negative or a positive connotation. And that's what Gabe's really talking about here. And this is really, in my mind, one of the most underrated but most powerful tools a trial attorney has.
And let me tell you a little secret that you're not going to hear a lot of people admit to this or say this outside of this context, but it's just as important, if not more so, in a bench trial as it is in a jury trial. Because despite what you may have heard, judges are actually human beings. Now, they don't think so. They see themselves as oftentimes, not always, they see themselves as able to, and I understand where they're coming from, but as able to weed out, information that's irrelevant or that it violates some evidentiary rule, or, counsel, I don't need, they think they don't need the emotional components or the sort of jury arguments. Reality is, judges are human beings just like the jurors are, and they will respond to the frame that you put on events, on facts, on testimony. I mean, advertising works on advertising executives just as much as it works on everybody else. Why? Because they're all human beings. And really, when we're telling these stories, we need to be able to do this, with the judge. We need to be able to do this with the jury and selecting these words. Now, a lot of times you will get witnesses who will fight you on specific words. And we talked about being able to punish witnesses. And so this is a great example of how you would do this, okay? Say a witness, you say, well, okay, and then the plaintiff was hurled from the vehicle. Well, I don't know if I'd say that she was hurled. Okay. Plaintiff exited the vehicle. Yes. Plaintiff exited the vehicle at a high rate of speed. Yes. Plaintiff exited the vehicle at a high rate of speed through the windshield. Yes. And then after passing through all that glass, the plaintiff landed 30 feet from the car. Yes. And so you turn that one question, they were hurled, into 15. And by the end of it, they're saying, hurled, please, hurled. Okay, I'll go with hurled. And they learn their lesson. Same thing. You're dealing with a witness or a case where it's important that one person was drinking. Okay. Okay, so you guzzled down 3 martinis at the bar before you went out to go pick up the Boy Scouts from the activity. Well, I wouldn't say I guzzled it, counselor. Okay. Or you get objection, argumentative. Counselor, I don't like the word guzzled. That's a little too argumentative. Okay, and so I won't go to drank. I'll go, all right, so you ingested into your body and into your bloodstream 3, 2-ounce martinis immediately prior to, yes. And those martinis come in a glass that's been iced. Right? Yes. Because you don't want to mix any water with your liquor. Right? Yes. So that's vodka, yes, mixed with vermouth. Yes. So it's liquor mixed with liquor. Yes. Okay. And you ordered that, sat down at the bar, yes. And you called the bartender over, yes, and you said, give me one of those drinks that's liquor mixed with liquor. Yes. And then you finished it. Yes. Set the glass back down on the bar. Yes. And then you call to the bartender, I'll have another, please. Yes. And then that one came. Yes. And you ingested that into your body and into your bloodstream. And very soon they're like, yes, guzzle them. Fine. Let's get it over with. And they learn that if they just go with your word, life is easier. It's still painful, but they get it over with, and they start to feel good about saying yes instead of saying no and then being like, oh, okay, we're going to do this again. All right, so we're going to go over here and we're going to go through and we're going to just beat it down with a hammer until finally you're like, yes, yes, please, please, leave me alone. Yes, I just want it to be over. That's what we want our witnesses to do.
And let me interject that a lot of this too is finding your own style, right? Because this style clearly fits Gabe. It's not so much my style. I'll give you an example of a different way to.
That's because I win my case.
I like to lose, so this is the style.
Patrick's goal is to he doesn't get. So that's the downside of being on the defense. You don't get to pick your cases. So Patrick's goal is to lose small.
Lose less.
Yeah, lose less.
Lose less money than. All right, so I'll give you the example off of my last trial. Carbon monoxide poisoning. Plaintiff says they have this traumatic brain injury. She works at a law firm. She's a paralegal at a law firm, and our theme is she was exposed. She got better, and she's fine now, and she's functioning in life. She's doing fine. That was our theme. They bring in her best friend, who's a co-paralegal with her at the firm. She gets up and she talks about how she's forgetful now, she's not as efficient, and she has to do, she goes off about how limited she is. My cross-examination, if I would have done it 10 years ago, I would have said, well, you're her friend, aren't you? and you're kind of biased to her, aren't you? And you want her to succeed, don't you? You know, I would have done kind of a destructive cross-examination like that. Instead, this time, I went with the nice approach. I went with the constructive cross-examination. I got her to talk about that. What you do is, it's pretty intense, right? You do really important stuff. You do really good work. Your firm's very successful, right? You handle this type of stuff, that's complex, right? You do this stuff, and I just lay it out, and I lay it out, and I go, and she does all of that, doesn't she? Yeah. And she's a good coworker, right? You like her? Yeah. And what did I just do? I showed she's functioning. She does this very complex job at a very high rate and does it very well. And the way that I approached it, she was with me the whole time. She was never wary of me. She was never looking at my questions like, yeah, you know, I was complimentary. What you do is really tough, right? Not everybody can do it. My paralegal sitting over there, she's the brains of the operation. You guys are the brains of the operation, right? And she's yep. Until finally at the end, again, Gabe's 3 rules, right? To a logical conclusion. And she does this, doesn't she? Yeah. And she does it successfully, doesn't she? Yeah. And she's a good coworker, yeah. And now, again, if she wants to, well, no, I mean, yeah, her job, it's tough for her to now backtrack and destroy everything we just laid down.
And a couple of good points Patrick made there that I want to highlight is that, okay, first is that you'll notice he never asks that last question that is he never asks the key question that is his, you know, what he's trying to establish in that chapter. Okay, because by the time which is, you know,
She's fine.
this person is fine. Because by the time, if you've done this correctly, by the time you get there, this should be obvious to everyone in the room, and you don't have to ask it. In fact, it's more powerful if you don't ask the ultimate conclusion. A, because conclusions can be argued with. We want to ask about facts. And B, because it's far more powerful to have the jury come to the conclusion on their own. Because jurors are much more likely to accept a conclusion they came to on their own than one that you just beat into them with a stick. The second point is regarding that tone. Now, I get really fired up talking about cross because I love it, and it's one of my favorite things to do. I love taking cases to trial. I love cross-examination, love all of this. But you don't have to be a big, fat, angry-faced jackass like me in order to make this style effective. In fact, it's more effective if for people who are smaller. I actually have to be very careful when I'm at, when I'm doing an examination, that I don't come across as overbearing, because that is, my wife tells me I have this resting bitch face that they accuse people of having, that I can be walking down the street and thinking about puppies and sunbeams and everything wonderful, and it looks like I just came from the murder scene, and that I'm French fried potatoes, and for all of you young people, that was a Billy Bob Thornton joke from way back in the day. Ask your parents. It actually works better if when you're smaller, and if you can use more tone, and I'll do that. Especially, you're going to want to adjust your tone to the circumstances. Like, I'd never question like a child witness or a teenage witness like that, or a sympathetic witness, someone who's been, heaven forbid, if I was ever defending one of these cases and somebody's been in an accident, and any of you who've done tort work have probably seen this, where it's a wrongful death case, child has died, and now we're examining the mother. And I've seen both. I've seen defense counsel just rip into her while she's sitting there bawling, mostly in depots, because somebody else usually gets a hold of that depot transcript on the defense side and says, oh my goodness, no, we're not taking this to trial. Or I'll see them go, okay, so, we're very sorry for your loss. Just a couple of questions. I'll ask it very simply. And, the style is the same. We don't have two different styles of cross-examination. We don't have different techniques, but you do have different tones. You have different ways to present your questions. And that's the beauty of sticking to these 3 rules is it allows you to construct these fairly elaborate cross-examinations and be able to follow them and leave you enough of your brain, enough of your attention to be able to focus on things like your tone of voice and your facial expressions and where you're standing and how you're moving and whether or not, and out of the corner of your eye, what's the reaction of the jury, okay? And that's critical, because you never want to raise the emotional level in the courtroom higher than where the jury is at. You can go up to that level, but never above, because the jury will turn and look at you and be like, you're an asshole.
And this is a little bit of a tangent, but I think it fits in nicely, and that's the dichotomy of experts. My mentor told me that the one place where you can be a complete asshole in cross-examination is to an expert. But you've got to preface it. And he said he'd get up in trials and he would say, "You're really smart, right? You've got this type of degree, right? You've been doing this type of work for 30 years, right? You're a lot smarter than me, right?" Kind of setting it up of like, we're on equal footing here. And then I go and destroy him because now the jury doesn't think I'm a jerk because we're two evenly matched competitors.
And see, even with that, I'll take a different approach, different style. Is I with experts, especially when I know I've got them, like there's some key assumption they've made that's incorrect, or some of their opinions are contradictory, mutually exclusive. I can ask them. I can be like, I'm sorry. I'm confused. Help me understand this. And then I start into my routine with these, and I'm kind of being done as a post. I'm trying to convince a jury that, gosh, this doesn't make sense, and there really isn't. And the reason it doesn't make sense is because it's fundamentally inconsistent. So the expert cannot resolve the problem.
Yeah.
And so I walk them through and highlight that.
And that's what I was going to say, is that I think that style can work and does work for some people. But I have to confess, I don't really do that either, because my concern is the expert's always smarter than me in their particular field, and they're going to eat me up if I get too much in the swamp. And so, again, going back to the last trial, I think of another example I had. We had the forensic therapist that was up there testifying, and there were lots of holes that I could punch into her testimony. But I, again, opted not to do the destructive cross-examination. I thought, how can I spin her to help support my system? Again, question of whether or not this particular lady has a lingering brain injury. And so she'd gotten up and she had talked about how she wasn't functioning, about how this was, how she was failing in life, and here, and here. And I got up and I said, there are lots of things can lead to that, right? I mean, there's stuff that everybody deals with. There's stresses of everything. And I printed off a sheet from WebMD. And I was like, I'm not a doctor, so I did what every good armchair doctor does. I went to WebMD, and they list these 40 major life stressors. You'd agree these are life stressors? Oh yeah, no, those are. And if I count through these and I look through your therapy notes, 27 of them are present with your patient, aren't they? 27, change of job, and then I went through the big ones, change of job, divorce, child custody issues, 2 lawsuits, and she was on board with me again. I'm just, yep, you're right, yep, you're right, yep, you're right. And again, as Gabe said, I never asked that ultimate question of, any one of these could be the reason why she's having trouble coping in life right now, couldn't it? I never asked that question because it was so obvious by the time we walked down it. And it was, again, that constructive of using their expert to help establish my thinking.
And again, this is the lawyer's craft, the trial lawyer's great skill is not just in having all of these options in your proverbial toolbox, but knowing when to deploy which one. Seeing, okay, this witness is going to be receptive to that kind of approach. There's a particular forensic accountant who thinks he is smarter than God, and he's here in Salt Lake, and half of you probably know who he is if you practice trial law, and the guy will never admit that he's wrong about anything. So playing dumb works really well with this guy because he slides right into that role of I'm smarter than you and you don't know what you're doing really easily. without even realizing it. And in cases where he's done something where he's either done some shoddy work, he's left something out, it can be extremely effective because he'll wind up trying to educate me about his own mistakes, which is fascinating to watch. So, you know, now we've only got a little bit left, about 10 minutes. So one thing that I think we would be remiss if we didn't cover, because as I said, it's the only rule of evidence that we all come out right out of law school having some understanding of, and so you're gonna go to it eventually, is this impeachment by prior and consistent statement. Again, to the extent you can impeach live with live evidence where, you know, that final unsaid question is, so what you said earlier isn't really true, is it? Those are the best impeachments. That's when life is perfect, when the jury can actually see it right there in front of them and you've got them. Now, as a fallback, if you've done it right and you want to use it sparingly because it gets a little, it can become a little tedious, but if you do it right, I can count on one hand the time I've seen counsel actually impeach for prior consistent statement correctly. And the trick to it is all in the foundation, okay? Laying foundation for the impeachment. First, you want to make sure, and one of the things I do before all my trials, even if I'm not planning on, you know, I don't think I'm going to need to impeach, is I will go through the depositions and I'll make sure, we talked about this in deposition sealings, one of the reasons why you guys ought to sign up for this entire series. In fact, you ought to sign up for the whole entire series. It's a great fundraiser for the YLD. That's where all this, your registration fees go. So, you know, great cause. But also, you know, in the deposition, after you've gotten the key information out, you always want to go back and ask the questions, you know, kind of in a wrap-up format where you can get that yes answer. You say, okay, so if I understand you right, just to make sure I'm clear, da-da-da-da-da, yes, da-da-da-da-da, yes, da-da-da-da-da, yes. Takes like 5 minutes maybe, and usually I don't draw any, you know, asked and answered objections because I'll preface it with, okay, I just want to make sure I've got you correct. And, you know, that's kind of code for this is going to be quick, just shut up, don't object, and it'll be over. And usually I'm able to get it in without a hitch. I wind up with a section of deposition transcript that has exactly the question that I'm going to want to ask at trial, and then a yes at the bottom, okay? And so once you have that, when you come time to impeach, you'll get up there and you'll say, okay, Mr. Witness, you recall previously in this case you received a subpoena. Yes. Now that's a court order. Yes. And that subpoena directed you to come to my office. Yes. And you brought your attorney with you. Yes. And that's her that's sitting back there at the table. It's been sitting back here at the table the whole time, right? Yes. Same attorney you've had throughout this whole case. Yes. And on that day, you knew well in advance what we were going to be talking about, right? Well, I didn't, but you knew what we were going to be talking about. Yes. Okay. Now, I didn't surprise you at that deposition. Well, no. I didn't bushwhack you on the street. No. You came to that deposition knowing what you're going to be able to testify about. Yes. You had a chance to meet with your lawyer beforehand. Yes. And you guys had a chance to review everything that you were going to testify about. Yes. And then, you know, if it's the first time I've done it, I'll say to the judge, and this is a rule that really has no purpose anymore, but it's still really, really fun, so I do it. I'll be like, all right, and they'll give you those original copies of the deposition transcript that are sealed in a little container. I don't know why they still do this. I don't know, they think somebody's gonna go in and like make their own fake little copy of the depo and be like, aha! Except that opposing counsel has a copy too, so it'd be pretty obvious, but they still do this. You'd be like, Your Honor, I request permission to unseal the deposition. And I'd be like, granted, because the judge knows what I'm gonna do. And I kind of looking at the jury and I hold it up and I rip it open and the jury's suddenly like, what is this? He's taking something out of a container. I'm curious now. And I'll flip it open and I'll put it up on an Elmo and I'll say, okay, At that deposition, you swore to tell the truth. Yes. The same oath that you took today. Yes. And you understood that. Yes. In fact, you were trying to tell the truth, right? Yes. Best of your ability. Yes. And I asked you da 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 da, and I'm reading it. And I say, did I read that correctly? Yes. And you answered, yes. Did I read that correctly? Yes. Close it and move on. Okay? The jury's just heard extensively. And a lot of times I'll try and put it, you know, if I'm cross-examining here from the podium and our table's over here, I'll put it way over here on the edge of the table. And so if I ever have to do it again, the witness will answer a question, I'll look at them and I'll go. I'll walk over there and I'll pick it up. And then I'll do a shorter version of that okay, you remember your deposition? Yes. You remember, you know, we were taking it? Yes. And then I said, and on that day I asked you, da 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 da. Did I read that correctly? Yes. Now you never want to hand them the depo. You never want to ask them to read it. Okay? Because they will say, well, I said da 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 da, but what I really meant was blah 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 blah. And they'll go on and say the exact opposite. And by the time they're done giving their little soliloquy, the jury's forgotten where you came from at the beginning. And so, you know, you put it up there and then you take it away and you put it back. And it gets to the point, if you've got a witness that's got, you know, problems sticking with the truth, that the witness will see you, you'll ask them a question, they'll answer you, they'll see you go like this, and they'll be like, yes, 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 yes. And then you'll be like, oh, okay. And you'll get back up there and you'll do it again. And you'll continue through. And now I can tell you that if you will apply these techniques in your cross-examinations, you will be a better cross-examiner tomorrow. You can walk into any case, okay, and even if it doesn't matter whether you have 6 months to prepare your cross, or if they spring a witness on you at the last minute and the judge lets them use them, you can prepare a basic outline with this, just coming up with the chapters you want to hit. After you've done it a few times, you can prepare it in 5 minutes. And it'll be more concise and it'll be more correct than anything you've done before.
And to highlight that, I'll just end with this. I brought this as an example. So I had a jury trial last year. We were, it was about 3 o'clock in the afternoon, and there was an anthrax scare at the courthouse. And so Judge Kelly made us pick up all of our stuff. Did not let us pick up our stuff. Made us leave the courtroom with nothing. And we all went out in the hallway, and finally his bailiff came and took us upstairs. His sheriff came and took us upstairs. Put us in this empty courtroom, and he said, well, it's 3 o'clock, let's just keep going. And we didn't have any of our notes, we didn't have any of our exhibits, we didn't have anything. I didn't even have I didn't even bring a legal pad or a pen with me. And I was up to cross-examine 3 more witnesses that day. And so they brought in these 3 fact witnesses. All my notes are still down in the anthrax courthouse. I turned to my secretary, she goes, I've got 1 sheet of paper and a pen. And this was my hurried draft up my cross-examination for 3 witnesses that afternoon. And it's as Gabe said, because I knew what tools I wanted to use, these were probably 3 of the best cross-examinations I've done, because all the fluff was cut out.
Yeah, it eliminates all the crap, right? Because when you have time to sit and think, we all get, if you really love trying cases and you love being up there in the spotlight and in the middle of everything, and you know, you're an attention whore like me, and you know, you're doing all of this stuff, you can tend to overthink things and you put it in there. Putting things into chapters and then winnowing it down to the questions you really need to make that fact logically unavoidable, it will really slim down your cross-examinations. The jury will love you because you'll go way faster, and you'll be much easier to understand, and you'll have comprehension from the jury, which is the road to victory. I mean, really, if you can tell an engaging, convincing story out of your case to the jury and get that through, you're gonna be tough to beat every time. Now, we'll end on that. Want to tell you a couple things. So again, if you want to see the video of this, or last one's the first one we videotaped and posted, so there's only the last one and this one, but it's at saltlaketrialattorney.com. There's a link on your materials to a podcast that we do. It's the Trial Lawyer podcast, and we're going to be recording an episode of that in a few days, where we're going to go over steps to deal with runaway witnesses on cross-examination. It's really fun, a lot of really entertaining stuff. So I'd encourage you to sign in and check that out. Thank you very much.
Thanks, everyone.